Awesome. Well, thank you guys for your time. So, we're really gearing towards our conversation for new parents, but you don't necessarily have to be like a new parent and say like, oh no, I have like a 10-year-old and I have to run away. It's really nothing of that sort. But so we really are going to be talking to all parents, but then the reason we said new parents also is because there's a lot of anxiety that comes with that, right? There's so many things you're thinking about and not that we're adding to your anxiety, but it's just like different a different way to look at how you want to be there for your children. So I can definitely introduce myself, and then we'll give a moment to Chelsea and Lillie to introduce themselves as well. So my name is Fahmin Fardous, a certified financial planner here at Zenith. I've been here about a year and a half. But prior to that, I was in the trust and estate planning space for about 10 years or so at a bank called PNC for about a decade. And that's where I realized there is a lot of generational wealth and there is a lot of power in estate planning overall. And we'll talk a little bit more about that. And, being at Zenith has really kind of reinforced my belief where you don't necessarily have to have millions of dollars to think about estate planning. And that's like the biggest myth we're going to debunk today. Like, you don't have to be rich to think about your future and what you really want to leave for your children and what kind of a legacy you want to leave behind. So I'll hand it over to Chelsea and then we'll go over to Lillie.
Awesome. Thank you for the warm introduction, Fahmin, and good evening, everyone. Thank you for joining us. My name is Chelsea Ransom Cooper. I'm the Chief Financial Planning Officer and co-founder here at Zenith Wealth Partners. Here at Zenith, we really pride ourselves on creating a flexible financial planning and investment management approach to really meet you where you are. And we do this by creating a comprehensive wealth planning service to help you with the whole gamut of your financial life, right? So we're talking investments, retirement planning, tax planning, insurance, cash flow, scaling, growing a business. And today we're talking about estate planning. So we really pride ourselves on helping people build wealth and understand what their wealth journey looks like and being their advocate all along the way. We also pride ourselves on really intentionally working with women and people of color to help them make smart and impactful financial decisions. So if you want to learn more, feel free to connect with Fahmin and I after this presentation. But I'll kick it over to our esteemed speaker that we have today, Lillie.
Good evening. Thank you, Fahmin. Thank you, Chelsea. Thank you for all of you for being on this call on this beautiful, is it Tuesday? Yeah, Tuesday evening to learn about estate planning in general, and then some specific lessons about how estate planning applies to young families or families in general. And speaking of families, you're going to hear my 4-month-old in the background. I'm taking this into heart with his dad. He says, don't forget about me, with his dad. So this is how you really juggle life. You give information to people while at the same time trying to manage your family in the background. So please forgive any little squeaks or cries or any of that. So I'm really looking forward to sharing this information with you all and to answering your questions. And thank you, Chelsea, Fahmin, and the whole Zenith team for inviting me to have this chat. So let's get into what is estate planning. I've been an estate and business planning attorney for 16 years. And as Fahmin said earlier, the biggest misconception is you need to be wealthy to engage in estate planning. And I understand where we get this idea because whenever we see estate planning, it's this really wealthy person who has a massive estate with horses, and then they die, and there's like a video reading of the will, and you get the Hampton house, and you get the Barbados house. And when society constantly drills into your mind that those are the only circumstances that warrant estate planning, you eventually will say, oh, that's not me. That's not my family. That doesn't apply to me and my family. Ergo, estate planning doesn't apply to me and my family. And I'm here to say that estate planning is for anyone who has assets they care about and people they care about. If you have assets and people, then estate planning is for you. Don't get caught up in the value of the assets. All that matters is I've accumulated something. I want to control how that something passes. And so I'm taking my power to be able to influence my legacy. I never say control, because as parents in the room, we all know you cannot control anyone, but you can influence. And so estate planning is your opportunity to influence the assets and the people that you care about, regardless of the value of the assets. The other misconception is you don't have to worry about planning until later in life. Again, the image is someone's on their deathbed and they're planning. Let me tell you something. Deathbed planning is the worst, and it's never done well. If you're already in the hospital, you're incapacitated, you're sick, you're weak, people are very emotional that you're about to pass away, that is absolutely positively not the time to plan, because everyone's emotions are heightened. Because your emotions are heightened, no one's thinking clearly. We don't have enough time to gather the assets and really gather your wishes. It tends to be a very rushed job. And so you never want to wait until you're much later in life, or you don't want to wait till you're incapacitated. I see kids come to me, adult children come to me all the time. I see adult children come to me all the time. My dad is in the hospital. My mom has dementia. My grandmother has Alzheimer's. I'd like to put together a plan for them. It's too late. They can no longer participate in the decision-making process. They have to have their mental faculties. So you don't want to wait until you're too old and sickly, and you don't want to wait until you've lost your mental faculties, because we can't do anything for you. So if you take away anything from this slide, excuse me, it's yes, estate planning applies to you, especially if you're part of a family, meaning you have children and a spouse. And no, you don't have to wait until later in life, and no, you don't have to wait until you're sick.
Thanks, Lily. Absolutely. And another portion I'd like to add a little bit as well is a lot of people also have the misconception that, they kind of don't understand what is part of like estate, right? Because to your point, Lily, it seems like it has to be millions of dollars. But then anything that is really like any assets, whether you have money in your bank account, whether you have a house, once you pass, that is part of your estate. That any money that's carried over, that's yours right now, after you die, all of that is called estate. So to Lily's point, anything that if you have any monies, whether it's $10,000 or whether it's $5,000, that still becomes a part of your estate.
Yes.
So it's huge to, just to have a conversation and think about what happens. And then, life also happens, right? Not to sound like so morbid, you might not even get the opportunity, to be in a hospital bed and make these decisions, especially when these emotions are heightened. So you don't want to have to, you want to have that peace of mind thinking my family is going to be taken care of, especially when you've got this young children. And we'll talk a little bit more about what that entails overall when it comes to especially children.
I love that. Yeah, that's a great point. Your estate is everything and anything that's in your name, anything that you own in the state in which you live. If you own anything out of the state, if you own anything out of the country, and if you think that someone is going to leave you something in their estate plan, meaning a parent is leaving you something in a will or a trust, that also will eventually become part of your estate. So let's get into what I consider the essential estate planning documents. Estate planning, there are levels of estate planning, right? So the planning that I would do for an Oprah Winfrey would be different than the planning I would do for myself, because we have different assets located in different parts of the world, and her plan is going to be more complex than my plan. But that doesn't mean I shouldn't have a plan. At the minimum, everyone, me, you, Fahmin, Chelsea, Jordan, Oprah, we should have these three basic documents. We should all have a will, we should all have a power of attorney, and we should all have a healthcare proxy. What is a will? A will is the orderly, it's the orderly distribution of your assets. The will is going to say, my name is Lily. These are my family members. If me and my husband die before our child is age 18, these are the guardians I name for my child. Pay my debts, because your debts don't disappear just because you're not here. And whatever is left, give to so-and-so, and then we wrap up the estate as efficiently and quickly as possible. That is the purpose of the will, to name guardians, pay your debts, and distribute your assets to the beneficiaries that you name in your will. So to Fahmin's point, whether you have 5,000, 10,000, 1 million, 10 million, you're going to want to have instructions that dictate what happened to your assets and your people when you're not here. So that's the will. The power of attorney and the healthcare proxy, I consider both of them to be emergency documents, meaning something has happened and you can no longer participate in decision-making. Alzheimer's, dementia, car accident, coma, severe depression, severe mental illness. Something is happening and you can no longer make decisions for yourself. These documents allow you to choose someone else who you trust to come in and make those decisions for you. So the power of attorney is your opportunity to say, if I'm incapacitated, I'm naming so-and-so to make legal and financial decisions for me. That means this person can have access to my bank accounts. They can pay my bills. They can sell assets if they need to. They can sign documents on my behalf. It's a very, very powerful document. So choose wisely. You want to choose someone who you know is going to do a good job and is not going to take advantage of all of that power. Similarly, the healthcare proxy is your opportunity to choose someone who can make medical decisions for you in the event you're incapacitated. This person can talk to your doctor, they can choose your course of treatment, they can choose your facility, they can have access to your medical records, because HIPAA does not allow anyone to have access to your medical records besides you and your physician. So healthcare proxy allows someone else to have access. I will say this, since we're talking about families, so often I hear people say, I'm married, I don't need those documents. My wife, my husband can make those decisions for me. And that's not true. Just because you're married doesn't mean that person can access your accounts. They can't have access to your credit card. They can't just pay your bills. They can't sign documents on your behalf. So even those of us who are married, we can't just say, oh, that's covered through the marriage certificate. It's not. Same thing with the healthcare proxy. There are instances where, kind of in the heat of the moment, a doctor might turn to a spouse and say, we need to do this, we need to do it fast, what do you think? And no one asks for a healthcare proxy. But for the most part, medical institutions are businesses. You know, Blue Cross and Blue Shield, your local hospital, these are all businesses and they need to protect themselves from liability. What if they turn to a spouse who's not really a spouse, who's estranged, they're going through a divorce, and that spouse makes a decision that the rest of the family doesn't like? There goes a lawsuit. So a lot of healthcare institutions are requiring a healthcare proxy so that they can turn to someone and say, James is not doing well. Can you make decisions, Jane? Jane, you're the healthcare proxy. Come in and help make decisions. So the healthcare proxy allows you to choose someone who can make medical decisions. The power of attorney allows you to choose someone who can make financial and legal decisions. And they are extremely powerful documents. And I'll say this for families who are sending children off to college. I know, 18-year-olds like to think they're adults, but the adults in the room know that they really aren't adults. And so one thing I encourage parents to have is to get their children to sign a power of attorney and a healthcare proxy, because a child who's out of the home but still is being financially supported by you, they don't have children of their own yet, they don't have a spouse of their own yet, something happens and they need someone to step in and make medical decisions, you may not automatically get that right simply because that person is your child. So I'd encourage spouses to have this for each other. I'd encourage parents to have this for their children who are off at college and unmarried yet. And I encourage those of us, myself included, to go to our parents and say, Mom, Dad, eventually you're going to get really old and you're going to lean on me for a lot. I need something in writing that says I can pay your bills for you. I can sell your home if I need to for Medicaid purposes. I can talk to the doctor. Even if they're not ready to do the other parts of estate planning, at least talk to your parents about getting the power of attorney and the healthcare proxy. So those are 3 different family settings, scenarios that if you find yourself in, that's a really good reason to get these 3 documents.
Absolutely, great points, Lillie. And one thing I've come across as well, there are people who have done they have a power of attorney and they're like, oh, I don't need a will, I have a power of attorney. And that is like the biggest misconception, because most people fail to realize that power of attorneys, they cease to exist at death. So, for example, I have power of attorney over my mom, and once she's gone, I can no longer make those decisions for her. So that, and a lot of people think, because my child has my power of attorney, I don't have a will. Now they can create a will on behalf of me, and that is not necessarily something you can do. So these are basically like, making those financial decisions in the sense like, you have to pay a medical bill. They cut out that check to pay, your insurance, or, pay that doctor. It's more of those type of financial decisions. But the power of attorney, is not you. So whoever you nominate, they're not going to be able to create estate planning documents for you. So these are, as Lillie pointed out, they're emergency documents. They are there in case of an emergency, in a sense where, you're incapacitated. That's where they come into play. And I've also had actually a previous client where their son was in college, and unfortunately he was 18 or 20, and he had a cardiac arrest, and he was in the hospital, and the parents were not able to obtain his medical records, and they were having a very difficult time. And it's because there were no HIPAA releases or a healthcare proxy, because he didn't name his parents. And it's a lot of hoops and loops to go through. So it's very, very important for children who are off to college as well.
That's an excellent point. So I would say to everyone, consider the power of attorney and the healthcare proxy, the documents that help you while you're alive but incapacitated, and the will is the document that helps you after you've passed away. So you're right, Fahmin. Everything you just said, absolutely excellent. The probate process. Ooh, the probate process. Okay. Everyone always says, Lillie, I need you to create something for me because I don't want to go through the probate process. I hear it's a terrible thing. I don't want it. I don't want it. The probate process is the court process to assess your assets after you've passed away and then distribute your assets to the beneficiaries of your estate. The probate process does not have to be time consuming. It all depends upon a couple of things. One, the complexity of your estate and how many assets you have, whether your family members are arguing or not arguing in the court, and where you live, meaning how busy is the court in your jurisdiction. Kings County, which covers Brooklyn, for those who are in New York, is a very busy court. So your matter will move through at a slower pace. But Westchester is a smaller court. Upstate New York and Schenectady is a smaller court. It'll move faster. So I'm saying that to say, I don't want probate to be the big bad wolf or the boogeyman. I just want us to understand what it means. Probate is the process of proving that, one, you've passed away, two, these assets belong to you, and that the assets should be distributed to your heirs. If you have a will, the assets will be distributed according to your instructions in your will. If you don't have a will, your assets will be distributed according to state law. And every state has different laws, but most of the time, if you're married and have children, your assets will be split 50-50 between your spouse and your child. And then there are other different rules depending on if you're not married or if you don't have kids. So the will is your opportunity to tell the court what you want to happen to the people and the assets you care about. But if you don't have a will, the court will tell you what's going to happen to the people and the assets that you care about. The role of the executor. The executor is the person who you name in your will that is supposed to take your will to the court and begin the court process. So I want to make that very clear. Let's say I have a will, I've named Chelsea the executor. Chelsea's like, okay, Lillie, I got you when you pass away. You know, I'm going to be really sad, but I'm also going to step up to the plate and I'm going to help you. She cannot do anything until she goes through the probate process first. The will in and of itself is excellent, but it doesn't automatically give Chelsea the right. She has to go through probate. That's why when people say, I want to skip probate, I want to skip probate, you want to go through probate because the letters that you get from the court is going to give Chelsea all of the authority that she needs, because she needs to go to Bank of America to close my accounts. Bank of America is not talking to Chelsea unless she has the letters from the court. She needs to go to my employer and tell them I've passed away and my 401k should go to my husband. My employer is not listening to Chelsea until she gets the letters from the court. So the role of the executor is to take the original will and original death certificate, complete the application that the court requires and say, here, this person has passed away. They nominated me to be their executor. I'm still willing to be their executor. Can you give me my letters so that I can do what they want me to do? You can choose an executor, any executor you want. The only rule is that they're above age 18. They don't have to be a spouse. They don't have to be a child. They can be your best friend. They can live out of the state. They can live out of the country. Although if they're out of state and out of country, it might be a little bit more of a burden for them to manage your affairs on the ground. But you can choose them if that's the person you trust the most. That is the role of the executor. Time and cost. The reason people like to avoid probate is because they hear that it takes a lot of time and it costs a lot of money. But again, the time is dependent upon the complexity of your estate, whether your family is fighting, and the busyness of the court in the jurisdiction in which you reside. I gave the whole upstate Brooklyn example. And cost. If you did the process yourself, the cost is the application fee, which can be as high as $1,100 because the application fee is depending upon the value of the assets you have. If you decide to hire an attorney because you feel like, oh, this is a lot of work. Chelsea's like, oh, I want to help Lillie, but I have my family, I have my business, I have all of these things going on. I think it would be better for me to hire an attorney. Then yeah, she's going to have the cost of paying an attorney to help her probate it. But she could also do it on her own and not pay an attorney, but that means she would really have to stay on top of things. And lastly, as part of the probate process, that's where the guardians are named. Remember, the will, amongst other things, allows you to name a guardian, but that's also not automatic. We have to take the will to the court. So in my example, Chelsea's taking my will to the court and she's saying, I'm the executor. Oh, and Fahmin is the guardian of Lillie's son. And we need you, judge, to officially name Fahmin the guardian. That's what Lillie wanted. You see here on page 7, that's what she wanted. But now we need you to make it official by giving Fahmin the guardianship letters or the guardianship paperwork. So the probate process is necessary for the executor to get their authority and for the guardianship to get his or her authority. And the time and cost is really dependent upon what's going on, but I wouldn't try to avoid the probate process because you really can't unless you manage to stuff every single asset that you have into a trust. And I've been doing this for 16 years and I've never seen anyone put every single asset that they own inside of a trust. It's just not practical.
Hey, Lily,
Yes,
we have a quick question because you just provided a lot of really helpful information about the probate
thank
process.
you.
And one of the questions we have is, does the probate process vary by city and state? And if so, like, what can you anticipate if you're dealing with somebody's a probate process for a family member in a different state?
Great question. It doesn't vary by city. It varies by counties. So for instance, Kings County, well, Brooklyn is a bad example because there's only one city in Kings County, but you might have a county that has different municipalities in different cities, but they all fall under the same umbrella county. It's the county that makes the rules for its probate process. So, you live in New York City, which means you live in New York County. New York County has its own website with its own forms and its own protocols. Most of the time, the counties in a state have very similar. It won't be so drastic like the Kings County process is way different from New York County, which is way different from Staten Island. They're in the same vein. Their paperwork might look different. They might have different requirements, and of course, the judges will be different, but it varies by county. State by state, it also varies, but I will say this, the common theme is they want the original will, they want the original death certificate. So I always encourage people, when someone passes away, get 10, 12, 20 death certificates, because every time you're interacting with these different entities, they all will want a death certificate, not a copy, an original. So order as many originals as you can. So they will all want the original will. They will all want the original death certificate. If you're saying that this person was married, they will want the original marriage certificate. If you're saying that a child is adopted, they will want the original adoption papers. So the consistency amongst all the counties and all the states are the documents that they want in order to prove that this person has passed away, in order to prove that they own the assets that they own, and in order to prove that there's basically no infighting amongst the family. And as long as you can produce those documents, hi, honey, as long as you can produce those documents, you're good to go.
Awesome. Thank you. And somebody else just asked, how many original copies of your will should you make?
That is an excellent question. Do not make copies of your will. Do not. The court wants only the original. Original means it's signed with ink. There's a stamp from the notary. There's a raised seal from the notary. Some notaries don't use a seal, but at least as long as it's stamped. They don't want photocopies of your will. So if you're going, and the reason why you don't want photocopies is because people are supposed to be updating their wills every 7 to 10 years. If I update my will, but I gave a photocopy to Fahmin, and she has the old language, but she doesn't have the new language. Now, when it's time to go to court, the question is, well, which one is the real one? You don't want that headache. Do not make copies of your will. Keep an original, and the executor, who's the person who's going to follow your instructions, should know where to find the will. So if you keep it in a safe deposit box or a home office, I don't actually recommend safe deposit boxes at banks because they're really problematic. But if you keep it anywhere else, as long as the executor knows where to find it, it's good. And anytime you change your will, shred the old one, only keep the new one. When you have multiple wills, it causes a headache, is the nicest way to put it.
Awesome. Thank you so much.
I completely agree, Lillie. And one point, and being at a bank myself previously, safe deposit boxes are not a good idea because once you pass, a bank is not one unless you have the original death certificate and the letter of testamentary or the short certificate, those documents you get from probate. From the court, they're not going to be allowed to go in anyway. And it's just a really big hassle. And the bank does not want to have any liability because the bank's not supposed to know what's in the safe deposit boxes. So it's better to avoid the process altogether if you can. Another point I'd like to add is the executor is not the same thing as a guardian. And a lot of times as I work with my clients, they kind of use those terms interchangeably. And it's not. So an executor is someone who is going to ensure your estate is being executed in the manner in which you wish. A guardian is someone who is going to make sure they're there for your children and make those decisions for them as if you were there until they are the age of majority, which is 18 or 21 in most states. Another thing parents to really keep in mind, especially if you've got young children, is think about who has the best relationship with your child. I mean, I've seen, like, even during conversations with couples, and it's so fascinating. The husband's like, oh yeah, my parents, like, they love her and they're going to take care of her. And then she's like, what do you mean? My parents are there all the time. And, I want my parents to take care of her. So, I've got two young girls myself. So, it's a conversation my husband and I have all the time as well. And what you really want to do is kind of set aside like your personal biases and look at who has the best understanding and the best relationship for your child. That's what really matters at the end of the day, because this person is supposed to be like your replacement if you both are not there.
Excellent.
That's super helpful. We do have one more question. Lillie, you touched on a really powerful point where you said you can't stuff every single asset into a trust to try to mitigate or avoid the probate process. But there may be times, especially as we're thinking about young families or blended families, where a trust may make sense.
Yes.
Can you talk a little bit about what those instances could look like, understanding we're talking to, new families or younger families?
Absolutely. I'm layering a trust on top of the basic documents if one of the following apply. You have minor children and you want to leave them a gift, but they're too young to receive the gift and you want the money to be managed until they reach the age of majority. That's reason number one. Reason number two, even once they reach a certain age, you're not comfortable with them just getting an outright gift. You want to give it to them over time. You want rules like you have to be age 25. You have to graduate from college first. This money should only be used for education or purchase of your first home or wedding. Anytime you have rules and parameters around the gifts that you're leaving, then I would use a trust. Another reason, there's an asset that you want to keep in the family, meaning I don't want to just give this brownstone to my son because knowing him, he'll turn around and sell it to the highest bidder. I actually want the brownstone to stay in the home, in the family for as long as possible. And people can use it. They can even rent it out if they want to. But I want this to be a multi-generational asset. If that's your goal, you put that brownstone in a trust. And then lastly, if you are concerned about your child's creditors, or your child getting a divorce and the assets you leave them being somehow swept up into the divorce, then I would use a trust. So Chelsea, I'm using it for people who have minor children and have assets that they want to leave. I'm using a trust for people who have rules and restrictions around the gifts they're leaving behind. I'm using the trust for families who have an asset that they want to keep in the family. Right now, I have 3 families that have rental properties in Martha's Vineyard. I mean, that's a hot asset to have. So they're not trying to just leave that in the will and have somebody sell it. And then lastly, if they're concerned about their child's creditors, or they're concerned about their children getting a divorce, I would use the trust. And I specifically said, I'm layering the trust on top of the 3 basic documents. People often ask me, if I have the trust, can't I just skip the will? And the answer is no, you want both. So I'm starting with the 3 basic documents. And if any of those other 4 criteria apply, I'm layering the trust on top of the 3 basic documents.
Awesome. I think that's super helpful and provides context as to, if that's applicable, how they should consider potentially using that vehicle. And you were right, Martha's Vineyard House. I know there's a couple on here who are familiar with it as well.
Yes.
It's a hot commodity as well.
It is a hot commodity. I was like, oh man, we should have. And I'm from Rhode Island and it never even occurred to me to. get that type of asset. And now here we are. Now you can barely rent a property in the vineyard, let alone buy.
Listen, you and I need to try and, someone leave me a Martha's Vineyard house. You and me both. Yeah.
Thank you. Okay, the probate process with children. Again, we've already learned that the probate process doesn't have to be terrible. It's a vital necessity. So let's talk about planning with real estate, because oftentimes parents, our beautiful, warm parents, have these ideas of leaving the house to the kids. This is our family home. It's in a great neighborhood. It's going to continue to appreciate in value. I want my son to have it. That's a great gift, but understand that real estate is a huge responsibility, because if there's a mortgage, then you're telling that person, here's a gift, but you have to pay the mortgage on it every year. Property taxes never go away. So here's a gift, but here's the mortgage and the property taxes. Oh, and the roof needs to be redone, and the floors need to be redone, and the landscaping needs to be taken care of. So the issue that I have found with leaving real estate is parents or elders leave the real estate, but they don't leave the child with any money to manage the real estate. If my parents left me a house, I would say that's nice, but I have my own mortgage. I have my own property taxes. I have no desire to live in that home again. Maybe we live in a place that's not like a hot rental market, so renting it out isn't really that viable. So now I'm in a situation where I have to keep putting money into it, or I have to sell it. And it's not uncommon for children to be torn apart, where they say, Mom wanted us to keep the house. And then another sibling says, we don't have enough money to keep the house. And that creates this friction. So if you plan to leave real estate, that's fantastic. But have a conversation about, one, whether the children want the property. Two, can the children take on the financial responsibility of managing the property? Three, if they cannot do number two, then what liquidity are you going to leave in order for them to do that? Are you leaving investments behind? Are you leaving life insurance behind? What money are you leaving behind so that they can manage the real estate property? Secondly, planning for blended families. It is not uncommon for spouses on their second, sometimes third and fourth marriage to come to me and say, I want to create a plan for my children, but I don't want to include my stepchildren. It doesn't mean that they don't even have a good relationship with the stepchildren. They could love the stepchildren, but they're thinking about the assets that they brought with them to their marriage, and they want to make sure that when they're no longer here, it goes to their biological children. There's absolutely nothing wrong with that. So planning for blended families requires a conversation of, are we planning in the sense where we're treating all children, biological and step, the exact same and splitting everything equally? Or are we, in this instance, treating them separately, and my assets go to my children and your assets go to your children? That is an important conversation to have when you have a blended family. And lastly, I'll say with point number 3, planning for families with special needs children. A special needs child or special needs dependent is someone who has some form of a disability and they are receiving government benefits as a result. You don't want to leave that dependent a direct inheritance, because you will disinherit them, or disinherit is not the word. You will disqualify them from their government benefits, because the government is going to say, hey, Chelsea, well, I won't use Chelsea in this example, Randy, we pay you $4,000 a month because of your disability, but we just see that your mom left you a lot of money. So you don't need the $4,000 any month. We're going to take that from you and give it to someone who needs it, because this is a needs-based program. In order to avoid Randy losing his government benefits, which he's entitled to because of his disability, we need to create a special plan for families who are planning for dependents with special needs children. We create a plan where they can have both. They can have the plan or the gifts that the parent wants them to have, and they can also have their government benefits. So I would say that these are three unique areas when we're doing planning for families: the real estate, the blended families, and families with special needs children.
Great points, Lily. And as I'm thinking about my previous life, I have a story to share for each one of these situations. And I won't bore you guys with the details, but I will say to your point about the real estate, I'll give an example. Let's call it the Blue House Trust. I've seen siblings torn apart and going at it with each other. And I mean, including CCing us in the email where, one of them wants to sell and the other one's like, no, mom wanted us to have this. And this house has been in our family since, grandparents. So taking care of those properties is a huge burden when it comes to real estate. So you definitely need to include like kind of like a escape clause where, at some point when it's not sustainable to be to financially upkeep the house anymore, at that point, it's okay. You have my permission to sell it. So it kind of, eases the discomfort with the children and also the arguments as well, because now hey, mom said if it's too much, then you can go ahead and sell it. So it's a great point to bring up when it comes to real estate and talk to your clients about. And it's something that I talk to my clients about it as well. It's like, do you want to take this money, sell it, and then have that invest and want it to grow for your children, or do you have like an actual emotional attachment with this property? If you do, you've got to leave something behind for upkeep.
Absolutely. I'm managing an issue right now. And I said, I think I should have charged you guys more because somehow I've been swept into this soap opera of a family. And I'm just like, this is a year and 2 years and counting between who wants to keep the house and who wants to sell the house. We don't have money. Yes, we do. No, we don't. Let's get renters. We got renters. The renters don't pay their rent. I'm just like, oh my God. Please don't be a part of that drama. Try your best not to be.
Absolutely. Does anyone have any other questions as well? I saw some of them are coming on the side, but wanted to send one more nudge for any additional questions.
I see Jordan has a hand up.
Yeah, so for a special needs child, were you saying that things should be put in a trust, or would you recommend entrusting a sibling to handle that?
I would put it in a trust. And this is why. The trust will have very specific language about making sure to make payments for the child in a way that it doesn't disqualify him or her from receiving their government benefits. You want those very specific instructions. That's firstly. Secondly, I hate to be the bearer of bad news, but when there's death in assets, people act very different. They act very different. The siblings are best buddies while mom and dad are alive, but when they're not here, things can go left. So this idea of I'll give my money to my daughter and I trust that my daughter will take care of her brother, it doesn't always happen in that way. Daughter could absolutely take that money and do whatever she wants to do with it, and brother is left in the wind. And to avoid the family feelings that come up when people pass away and there are assets, I tell people all the time, death and money changes family dynamics very quickly. So to avoid that, use the trust as the middle person so we can minimize those issues.
Awesome. Thank you. We do have another question. We have a few questions that just came in. So one is, what happens when dad wants to leave some money or some assets to stepmom, but the children are older and think all the money should be left to them?
So in your scenario, dad wants to give money to his wife, but the wife is not the children's biological, it's their stepmom.
Correct. And the kids think that they should get the money.
Oh, yeah. Okay. So I'm sorry, children, but there's no legal requirement for your parents, for our parents to leave us anything. There is a legal requirement for you to leave a minimum amount to your spouse. Every state has a minimum. Most states operate around 1/3. So every spouse has to leave at least 1/3 of the value of their total assets to their spouse. So if children are complaining that dad left everything to stepmom, there's nothing they can do unless they're trying to say stepmom manipulated him to put that in a will or bullied him to put that in a will. They don't have any, children don't have legal rights to their children's assets, to their parents' assets, excuse me. So sorry.
Makes sense.
Yeah.
Well, we have another one. It goes a little bit in a different path, but let's say once we have our estate documents set up, how often do we go through this process of reviewing them? Like, are there specific like lifestyle changes that occur where it's like time to now implement or adjust or review your estate documents?
Yes, I would say on average, every 7 years, dust it off, look at it, make sure it still makes sense. In addition to that, if life events occur sooner than the 7 years, that is a good opportunity to review it at that point. Life events are marriage, divorce, new child, an increase in wealth, a new business, leaving the state, leaving the country, adopting, which falls under new child. Those are the triggering events that you should say, oh, let me go review my documents. Or even a beneficiary, someone who was named in your will or your trust as a beneficiary, but they passed away before you did. Now you should go update your documents. Those triggering events should tell you, let's go update now. If those don't happen, at least set a reminder to check in every 7 years or so.
Awesome. That's super helpful. So dust it off, if everything stays the same, but if
Right.
not, whenever there is a triggering event, make sure you look at it or talk to your financial advisor and maybe sit down with them or the person. Can you go back to the person who created the documents for you to like go through that review process?
I would go to the attorney who reviewed it. If that attorney is no longer in business, or either because they closed their firm or they've passed away, or they don't do that type of work anymore, I would take the document to another estate planning attorney and say, hey, can you look at these documents? Someone else created it, but can you look at it and tell me, and I'll tell you what's been going on, and you tell me if I need to make any changes.
Great point, Lily. And for our young parents, the most common executor tends to be, from what I see, guardians and executors tend to be grandparents. So, if your parents pass away, that is a great time. I know it's such a huge loss in your life, but once you've kind of recomposed yourself, that is a great time to go ahead and review your state documents to make sure, hey, I wanted my parents, I didn't really have a backup, or do I really want that backup person to be like that, still be that guardian for my child, or still, carry out my estate and be the executor? Because if you don't, then at that point, it's going to go back to like the court process, and the court's going to end up deciding for you. So you always want to make sure that's staying up to date.
Great point. And in addition to parents, many of us name our spouses as executors and agents and trustees. And if we get a divorce, that's another opportunity to go back and say, I should probably take that person's name off of these documents.
Absolutely. Well, we have one more question, but I want to make sure we can touch on our key takeaways and then we'll close it out.
Okay, great. So key takeaways from my perspective: start thinking about who should be the guardian of your children. The biggest hiccup I find is people are split between, well, who's good with raising the child and maybe who's going to be good with managing the money for the child. So there's a such thing as a personal guardian and a financial guardian. One person can do two of those roles, but if it's easier for you and your family, you can split it. You can say, my mom would be fantastic raising my son, but my sister would be great with managing the money that I've left for my son. Instead of racking your brain, split the responsibility. Who would you like to handle your estate? I actually did a post on this today. You have to look into who you trust. This person is going to have access to your assets, access to your account. They're interfacing with the rest of your family, and they're interfacing with the court. So if you would choose someone who no one in the family likes or trusts, that's going to be a problem, because they are now your representative, and nobody's ever going to believe anything that they're saying because they didn't trust them when you were alive, and they really don't trust them now that you're no longer here. So choose wisely. Who do you trust to make financial and healthcare decisions? Same thing. You want this person to be trustworthy. If for some reason they start to behave in ways that you feel aren't worthy of an agent, cancel the power of attorney, cancel the healthcare proxy, and choose someone else. And then lastly, the probate process. It doesn't have to be scary. You don't have to have heavy feelings about it. Just know that it's advantageous so that the executor can be officially knighted, if you will, by the judge, so that they can start doing what they need to do, because you need them to close accounts, you need them to pay bills, you need them to negotiate with your creditors. You might have an outstanding Visa bill that we can't pay, and now we need to talk to Visa about whether they're willing to accept $500 instead of $5,000. Your executor needs the power to do that, and he or she doesn't have that power until the probate process is complete. So think of the probate process as a process that empowers your executor. It empowers your guardian. It doesn't have to be something that you avoid.
Excellent. These are all great takeaways. Fahmin, anything you want to add? Excuse me.
No, I think, they are really great takeaways overall. And, thank you for highlighting the probate process also, Lillie, because that is such a common fear that clients have, especially in the areas we live, right? In the tri-state area where probate is a long, drawn out process overall, and I always like to set the expectation. It can go anywhere from 9 to 18 months, but then it also depends on how complex your situation is, right? And, if you don't have, especially young children, it's not necessarily something to be afraid of overall, but you just want to be mindful. And then, there are other ways also we can make sure your accounts are titled in an appropriate way. So that is also a great time to kind of just talk to a professional about like, hey, I do like the probate process, or I don't, but I just want to make sure I'm ready and I'm leaving less work for my guardian or for my executor, especially when you have young children that they have already so much on their plate. So you want to also try to make their life as easy as possible instead of leaving them with tons of paperwork that they have to file. So, just when it comes to like titling your accounts, that might be a really easy way to kind of cut down on some of the paperwork they have to go through.
Excellent. Yes. Retitling or properly titling accounts skips the probate process, and as many assets of those as we can have, great. For everything else, the will catch everything else that doesn't have the right title on it.
Absolutely. Well, we have one more question, and it says, if you have a rental property that you put in a trust, can you automatically include that income from the property into the trust as well?
Yes, because
Yes.
oh, go ahead, Fahmin. Go.
Thanks, Lillie. Yes, there is, without getting too granular, there are two types of trusts you can have. One is any income that's generated, it has to kick out, which is, your simple trust. And any type of income that's going to stay in the trust is part of a complex trust. So to answer your question, Hiba, that is something you can certainly do, where the income is going to stay, and then it can also get added to principal for the account to grow on its own overall. So it doesn't have to kick out on a regular basis if you don't want it to.
Excellent.
Excellent. Well, thank you everyone for joining us. We are right on time. If anyone has any last questions, feel free to post them in the chat. But Lillie, if anyone has any estate planning questions or they want to connect with you, where can they find you?
They can go to my website and schedule a consultation. We set aside 60 minutes to speak with potential clients to really deep dive into their matter. Or if you're like, I'm not ready, I just want more general information, then just follow me on Instagram, where right now I'm doing a pretty good job of posting content. I wasn't always that way, but right now it's flowing and I'm touching on various business and estate planning topics. So that's a great place to gather information while you decide when you want to consult with me so we can get into the details of your matter.
Listen, Lillie is underselling it right now. Her content is top tier, top tier. The videos are fantastic and engaging.
Thank
Key
you.
nuggets that you need to know as you're thinking about estate planning for you and your family, and also growing a business as well.
Thank
And
you.
Fahmin, if people want to learn more about Zenith, where can they find us?
You Google Zenith Wealth Partners, and we're going to be the first one. It's we work with our clients from all different spectrums, right? We meet our clients where they are. So you can find us on Instagram, you can find us on LinkedIn. We obviously have our website, so you can certainly find us in any which way you would like to. And feel free to reach out to us as well, if you have any ongoing questions and if we prompted any thoughts from our conversation today.
Excellent. Well, we will share this recording as a follow-up if anyone has any additional questions. And
Right.
thank you all for giving us some time this evening, sharing and learning more about how we can protect our families through legacy planning and estate planning.
Wonderful. Thank you, Zenith.
Thank you, Lillie.
You're welcome.